To the Point with Michael Williams.
Good morning. The Donald Trump criminal cases starting with New York, but of course including the legal threads running through Mar-a-Lago, classified documents, and much more. My guest, a familiar face, noted criminal defense lawyer Stuart Kaplan, former FBI agent. Thank you for being with us.
My pleasure.
Let's run through what really is going to be a historic year, assuming all these trials are to happen this year and the next year, year and a half. But we'll begin with New York, and I'm going to have you put your defense lawyer hat on and run through these cases kind of one by one, and then we'll talk broader themes. The hush money case. Politico did a great synopsis of pros and cons of the case, but we want your take. They say strengths of the case. Michael Cohen, former lawyer for Donald Trump, paid Stormy Daniels, former porn star, and said she was allegedly reimbursed by Trump, who then turned against his former boss, did Cohen. As a star witness for the prosecution, he's expected to testify. Trump directed hush money to keep word of an affair secret so it didn't affect his 2016 campaign. You're in that New York courtroom in the coming weeks. Defense lawyer, what's your biggest argument?
I exploit Michael Cohen. He's a proven liar. He's a convicted felon. I think he presents poorly. I think he will turn off the jurors, and I just think the bigger prize here is that while Donald Trump may have paid money,
which is not a crime in and of itself.
It is not a crime, and he was married at the time, and quite frankly, as we saw in the Governor Edwards case many years ago, that's a personal matter where he's trying to protect the integrity of his marriage.
The argument here is that he falsified business records to do it, but there was a point where the feds wouldn't take on the case. And I have heard you routinely hear academics say of all the cases, they feel this could be the weakest. Do you agree or disagree?
I believe that this is the weakest case. However, what would concern me the most
as a defense lawyer,
is that New York County is predominantly a Democratic Party city, and the makeup of the potential jury pool would be the biggest concern that I would have.
But you feel this case is a reach legally?
Oh, this is a far overreaching type of scenario. Keep in mind, Michael, the feds turned away from taking this case. Cy Vance, who's the former district attorney for New York County, turned down this case. And of course, look, there is no doubt that the statute of limitations with respect to the misdemeanors had long since passed. And then to try to backdoor and back into this, they came up with this novel approach to now charge him with a felony, to extend the statute of limitations to 5 years. And I want to say also one other thing. The fact that Alvin Bragg, the sitting district attorney for New York County, campaigned and identified that Donald Trump was on his target list if he got elected, that to me is the most offensive, concerning thing. And that should be the most concerning thing to all of us here in the United States.
Let's turn to the classified documents case. Of course, the ties to Mar-a-Lago, classified documents, the FBI, the raid by the FBI there. The case there, Politico says strengths of the case. Many legal experts, including conservatives, it writes, have described the indictment as laying out an exceptionally persuasive case. It contains evidence, they go on to say, from Trump's own statements that he knew he was not authorized to retain classified material, but did so anyway. How do you attack that?
So the difficulty in this case, quite frankly, Michael, is before any subpoenas go out, before any grand jury subpoenas are served, I have no problem with attorneys jostling or strategizing with respect to even stonewalling the government when they're asking or requesting voluntarily for you to turn over documents or to return documents that may belong to the government. But once grand jury subpoenas go out, whether you are right or wrong, you must comply to the letter of the law with respect to complying with what they're asking for. My biggest concern in that case is whether or not anything may have been done. And I think there was some...
So you're worried as a defense lawyer that if you didn't comply, the prosecutors can have a case, because whether you like their case, whether you agree with it or not, you got to comply and turn over the documents.
That is correct. But keep in mind, Donald Trump had many lawyers in between him and the government.
And he can argue.
And he can argue that he took the advice of counsel and that whatever happened or didn't happen is the result of bad lawyering.
And we'll also hear a debate there, I would imagine, about whether I could declassify documents. It's been a huge debate. Many academics say there's no way he could. Presidential record laws don't allow it. Nonetheless, others say it could be an argument that persuades jurors. Fair?
No question about it. And then, of course, you have the bigger issue for everybody is the double standard, because we now know that
the Joe Biden case.
The Joe Biden. We know that Joe Biden has had classified documents in his possession going back 30 or 40 years ago, and we don't see Joe Biden sitting in front of a jury being judged in a criminal case.
You know the argument, he willingly turned the documents over, there wasn't overt. You've heard the argument. What do you say to that?
So the law does not judge whether or not it was a willingness, meaning the fact is, did you take classified documents from a place that you were not authorized? And clearly, Joe Biden, who was not the president at the time he came into possession of classified documents, there's no argument that can justify him to have been in possession of those documents. At least from the president's perspective, meaning Donald Trump, he was the sitting president, was authorized to be in possession of those documents.
Let's go. We've got two other cases. I'm going to touch we've got the Georgia election interference case, the whole Fani Willis controversy there. We'll touch on that another day. But thematically, it goes to election interference, and you have the January 6th case out of Washington, D.C. I want to touch on that because I want to give you also a chance to talk on broader themes. Politico says, strengths of the case: Trump's effort to subvert the election, extensive, well-documented, largely in public view. Recorded phone call with Brad Raffensperger, former Secretary of State in Georgia, saying, can we find some votes here? What are the weaknesses of the case that defense lawyers can go after? Because many argue this is a very strong case.
Again, I think that Donald Trump was within his right to have those type of conversations. I think that not only did Donald Trump believe that the election was stolen, I think many Americans thought also that there were irregularities that rose to the level of questioning the veracity and the integrity of the election. And so I'm not so sure that I see an orchestrated effort, a conspiracy. I think that there were individuals who were impressed by the president's stature, and they then took and ran what they thought would be favorable to try to help the election.
But on that day of January 6th, so much emotion surrounding that day, so much debate about whether he's liable for that, and sometimes that gets conflated. I hear you arguing what happened, awful as it was, and I'm talking about the physical assault on the Capitol. You're saying can't be laid at the feet necessarily of the president. Some say it can, that he threw the match on the gasoline.
I don't see it that way, Michael. I see him exercising his right to free speech, and certainly we have seen many politicians more recently in the last 5 or 6 years, and certainly during the Black Lives Matter riots and protests, where there were politicians saying on record, we will not hold you accountable. We understand why it is that you're burning cities down, why it is that you're damaging property. The politicians, you talk about inciting people, that was the classic, perfect textbook example. I don't see the same for what Donald Trump did. And may I say one last thing?
Of course.
Most of the people that assembled at the Capitol were already in Washington, D.C. This is not a scenario where Donald Trump got in front of a podium and said, okay, everybody get on the buses, get on a plane and go to the Capitol. These people were already there in protest. I think that's a big factor in the favor of the president.
And again, you're speaking with your defense lawyer hat on, Stuart Kaplan. Most of you know him quite well, former FBI agent and noted criminal defense lawyer. We'll get to the Georgia election interference case another day. Some of the same themes there, but I want you to, in our remaining time, talk more broadly. We don't even know if any of these other cases will get to trial this year. Some have argued the judge in the classified documents case is dragging her feet. Others have made arguments about other cases. Nonetheless, the legal system, many argue, itself is taking center stage and is being stress tested. What are your broader concerns in your closing remarks about the legal system, the stress it's under, and this historic time we're living in? Final thoughts.
I don't think I only speak for myself. I think I speak for all Americans. The greatest threat to our democracy is the fact that if our due process rights are eroded, there's a reason why the scales of justice, she has a blindfold. And that is because the justice system should be unbiased and not allow outside influences to determine the course or the trajectory of a criminal case. The hypocrisy of trying to suggest that all of these cases in some way try to interfere with an election Look at Donald Trump right now. He's handcuffed, literally handcuffed, that he can't go out and campaign because for the next 2 or 3 months, he has to remain in New York County and be a participant in this criminal case. And I think that there's such a danger to that, and that's a very slippery slope. The other common theme and thread in all of his cases is that all of these prosecutors, prior to entering into the position that they are now entrusted with, all campaigned on an agenda to get and identify Donald Trump, that if you elect me and put me into office, I'm going to get Donald Trump.
Jack Smith, I don't recall any such thing with Jack Smith.
Well, before Jack Smith became a special prosecutor, he's on record saying that he was not a fan of Donald Trump. Now, he didn't have to campaign or become an elected official. So let's leave Jack Smith aside. But we take whether it's in Georgia or New York or anywhere else, they're on record, meaning those prosecutors are on record that they believe that if you put me into office, if I win your vote, I'm going to go after Donald Trump. That's a dangerous trajectory for the United States of America.
We'll have to leave it there as these cases begin to roll out again. We don't know if any others will make it to trial this year or if they'll be finished before the election. That brings a whole separate set of issues. Stuart Kaplan, as always, we appreciate your insight. Stuart Kaplan, former FBI agent and criminal defense lawyer. Thanks for being with us.
Always my pleasure.
He was one of the most prominent and beloved leaders in Florida history. A look back next at the life of Bob Graham.